As the court has repeatedly pointed out, Mr. Demons is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing a death penalty here. So the risk of flight for him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
YNW Melly's highly anticipated retrial is just 4 months away, but his defense team is pushing for his release on bond ahead of the court date.
6 years ago, spent 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically.
I'm Elizabeth Milner with Lawn Crime. Jamell Demons, also known as YNW Melly, has been held in a Florida jail since his 2019 arrest more than 6 years ago. During that time, Melly stood trial, which ultimately ended in a mistrial after the jury couldn't reach a verdict. Despite facing 2 capital murder charges, his defense team continues to push for bond, offering several compromises if the judge permits his release.
There's no law nor statute that says, or rule that says we can't come back and argue for his release after a year and a half of what's been going on.
I agree with you. That's why we're here today.
This week, the courtroom was packed, largely with YNW Melly's family, as the Florida rapper appeared before a Broward County judge. Before hearing arguments on whether Melly should be granted bond, the judge first listened to the lawyer, representing the victims' families.
I think the victim family members just wanted us to at least place an objection on the record, let their feeling be known. Of course, under Marxist law, we have that right. And so we filed that objection just so Your Honor knows what their position is and our position is here, that we would be, if family members would be objecting to any of these in this case.
During Tuesday's hearing, the defense attempted to call Dr. Heather Holmes, a forensic psychologist, as a witness. However, the prosecution wasn't about to let that happen.
We're going to be objecting to Dr. Holmes' testimony just because she was noticed in the state less than 36 hours ago. She was testifying as an expert. We don't know what documents she wanted that on. We don't know what materials she was given to review. We provided no reports nor do we know the substance of the testimony.
When was she listed as a witness?
She was listed, I believe, Friday evening after we had hired her. She must have had a break from the doctor. There was no report.
She was listed.
Stop. This was Friday afternoon.
I believe so.
Okay.
I played 4 or 5 and came in and saw last week. It was about Sunday evening.
So you don't want the testimony to be considered today anymore?
We'll find bifurcating once we have that time to know what to testify to, know what we rely upon, have time to look into that. But today, with the difference of less than 36 hours, we're not involved there.
Is she in fact testifying next week?
She is testifying as to basically the second portion of my motion going to the appropriateness of the bond. So I am tendering her up there. She did sit with them. She has information to provide to the court.
She interviewed your client?
Yes.
She's going to testify about that?
Yes. And just so you're honest, the e-filing from the court, the clerk's portal came in at 10:31. We have on 5:7.
Okay, so the state's objection is to testify.
It was a setback for the defense, but the lawyers still pressed on, continuing to present their arguments and make their case.
The circuit court may exercise discretion to grant pre-trial release if the defendant can prove conditions of release. If the defendant can prove that his conditions of release can effectively protect the public from the risk of physical harm, assure his presence at trial, and protect the integrity of the court. There are some other factors that we get from other cases talking about flight, is he a risk of flight? So going through that. What we would be proposing for Mr. Demons would be a minimal monetary bond with the condition that the defendant would remain at his new residence. The defendant would not have possession of a firearm. The defendant would wear the standard pre-trial ankle monitor for GPS tracking. I did put on that witness list, I will not call him, was a member of the security company who we have engaged to. One, it was twofold what I had asked for. Mr. Demons would have a 24-hour security guard on his person. There would be then 2 other security guards on the property to basically secure the premises of the property of the house and the house. They would be reporting if there was any infractions of Mr. Demons. They would be reporting directly to myself, the rest of the legal team, the state attorney, and to the court. You basically have your own deputy, paid deputy, with him. Mr. Demons is not a flight risk. He does not possess a passport. I don't even believe he has a driver's license at this time. We can assure his presence at trial. He's been here every hearing. He will be here every hearing. He would have a monitor on him. The court would know where he would be at. There would not be any concern, actually, with him not being at court because you know where he's at all the time. My proposal, with the security on, with the GPS tracking, basically house arrest, it would effectively prove conditions of release can protect the public from risk of physical harm. Given the singular event that Mr. Demons is being accused of, it was not like, and I was looking at the different case law when we're talking about danger to the community. Most of the times dealing with a drug dealer and you're in fear of him coming out and still dealing drugs in the community. That's not the issue here. Again, it was a singular event. If there was a concern for public safety, I think I would meet that concern when we would with our stipulation to the house arrest, the prohibition of firearms, and the ankle monitor. I think we could secure that there is no threat to the harm.
So GPS tracking, a 24/7 security guard, money to post bond, that pretty much sums up what the defense is offering. But Melly is also charged with witness tampering, something the judge will likely take into consideration. But the defense had an answer for that too.
That case was very convenient. It was filed while we were pending our last motion for bond. And it does affect the integrity. You recently heard our motions. I was trying to lift the state to argue that motion. The only person my client has been accused of tampering with was Mariah Hamilton. However, going specifically to that statute, it would require Mariah Hamilton was actually summoned to a legal proceeding. That legal proceeding is defined by that statute. The only thing that would be applicable was Mr. Demons' trial. I've said it many times. The record is devoid of any proof that Mariah Hamilton was ever under a legal obligation to come to trial. She wasn't. That is the only basis of what the state will argue, is that he's tampering with witnesses. There's been allegations he tampers with this person, he tampers with that person, but there's no proof of it. We deal with, and I was based off the previous motion, not written by the state. Based off the true facts, there's not been any tampering. When we look at these cases, and it was interesting because with both the constitutional right to this bail, it does give that exception, except for people who are facing death penalty or capital fines, lifetime fines, right? And you go to the next provision that says, hey, if you appeal something, you automatically have that right, except if you're charged with a capital fine. So I did some research on that. And the whole basis for it, because there was a case that came later, and my apologies, I didn't write down the site on it, but it goes on to explain that you would not have been given a right, i.e. the right to bail, and then a certain class of people denied bail under that same provision. And they go on further to explain in the history of it, is that initially when somebody was faced with a penalty of life in prison, they feared that that person would abscond or they would flee. Mr. Demons knew he was going to be charged with 2 counts of first-degree murder. At 19, he could have ran, not did anything. He did the right thing, Judge, and he turned himself in. I believe February 13th, 2019. 6 years ago. So it's 6 years of his birthdays in that jail. The last 3 years that he spent in that jail, he has been deprived of basic human needs, basically. He's currently housed in a situation that's 23 and 1.
Counsel, he conducted additional evidence.
Okay.
Lawyers can keep evidence. So if you want to present some evidence, I read that in the pleadings, but there's nothing in front of me about what his current conditions are in the jail. So
Okay, good.
we just go ahead.
So, the conditions in the jail aren't good. He's been there 6 years, Judge. The Constitution says everybody gets the presumption of innocence. 6 years. We're going now past 6 years. He has substantial ties to the community. To his mom, his grandma, his sister, his brother, his friends, his grandpa. They're all here supporting him. The special conditions are there, and that's what we get out of the different case law. That proof evidence great, that's one thing. You go to the second. Are there special conditions that we can put in place to protect those 3 things? Make sure he's present here. Make sure there's no harm and the integrity of the judiciary. I don't have any evidence before you. You were precluded of putting my witness on. He has no risk of flight, though, Judge. I don't think there's anywhere in this world that Mr. Demons can go at this point without being known. There is no danger to the community. This was an insulated incident that he's being accused of. But again, I believe the special conditions that we put in place would protect the public from any risk of harm. They would also assure his presence at trial. And again, we would be protecting the integrity of the judiciary. And I believe the amendment, the state has not presented to us any reasons or any special conditions that would say that he should not be eligible for a bond. And I will also just point out that the whole purpose of bond is not to punish the defendant. It's to assure their